Started. I'd like to thank everyone for coming to our newly titled Antitrust, Does It Work for Tech? As Dan Caprio mentioned this morning when he was speaking with Commissioner Wilson, this too is a highly topical and timely discussion. I actually had to throw out a bunch of my notes that we'd previously put together. Rather than going through long bios and opening statements, I'm just going to kind of run down our panel and then we'll just jump right into it. Sitting to the right of me is Keith Klovers. He's the attorney advisor to Commissioner Christine Wilson, FTC, who you heard from this morning. To his right is Jeff Farrah, general counsel for NVCA. Then we have Chris Lewis, the new president and CEO of Public Knowledge, and Alex Okuliar, partner over at Orrick. So when we sat down to kind of flesh out what are we going to do for IGF USA, this was back kind of March time. Senator Warren came and said, Apple, you've got to break it apart from their app store. It's got to be one or the other. You had Senator Hawley saying, we need to have a discussion about what antitrust looks like when applied to our tech world. It's become a very populist discussion. You hear it on the campaign trail. And we were going to have a nice deep dive into this whole issue, but then all of a sudden stuff jumped off over the past week, and we had U.S. Treasury Secretary Mnuchin said yesterday, Amazon has destroyed the retail industry across the United States. It's absolutely right the Attorney General is looking into antitrust issues. You had two House Judiciary hearings on antitrust, one just last week, which included Google, Apple, Amazon, Facebook, former Chairwoman Olhausen from the FTC, who you'll hear from later today, ACT and NetChoice. There were some strongly worded letters from the committee chair to the companies. He had some issues with what was said. And then, of course, 2 days ago, the Department of Justice announced their investigation into an effort into big tech. And just yesterday / today, and we'll jump into this, the DOJ approved the T-Mobile Sprint merger. So we have a lot of news that is coming down right now that we're going to talk about in a sec. Before we jump into that, I did want to do a quick explanation of, if I can get this to work. There we go, cool. Just antitrust, where does it come from? This will be very brief. Sherman Act, Section 2, I think it's always worth noting, very short act, section. Every person who shall monopolize or attempt to monopolize or combine or conspire with any person or persons to monopolize. That is the genesis of what we're talking about today, Section 2 of the Sherman Act. Essentially, monopoly requires market power and the willful acquisition or maintenance of that power as distinguished from growth or other development. So basically, you are a monopoly, you have market power, and you're doing bad things with that. And then we'll jump into some use case analysis a little bit later in the discussion. But I want to turn to our panel just even before we jump into kind of the opening questions, and instead talk about some of the breaking news that we're hearing. So Chris, I mean, Public Knowledge has been very active on T-Mobile Sprint merger. What are your thoughts about the antitrust monopoly concerns and some of the public concerns that you see going forward on this?
Sure, and thanks for having me on this panel. You know, when it comes to Sprint T-Mobile, we feel like, and we argue that that merger is pretty clear cut, that there are harms to the marketplace moving from 4 nationwide wireless carriers to 3 nationwide wireless carriers. And that the record that has been submitted by the merging companies points to the impact that it can and will have on consumers. There's no ability for the companies to make a guarantee. They haven't been able to make a guarantee that there will not be a raise in prices. There will be a severe harm to the wholesale marketplace. We believe, since Sprint and T-Mobile are the 2 major low-income wholesale sellers. And so it's no wonder that, the rumors that we hear, and we haven't heard a final decision from the DOJ, but, it could happen while we're sitting here, according to the rumors in the news. It's no wonder that, the DOJ staff in their recommendation suggested not moving forward with this merger, and that all of the chatter is around finding a way to work around the merger to ensure that there is a fourth competitor. I think there's a high bar to actually creating a fourth competitor, but we will see what comes out of the DOJ announcement, and we'll all be able to analyze it.
Yeah, I noticed you talked about harm to consumer, which is kind of the basis on which antitrust is centered here in the U.S. Commissioner Wilson spoke about that earlier this morning. On that, we've got now the DOJ looking into efforts and an analysis of big tech. We've got two people, one of whom worked both at FTC and DOJ, and one currently at FTC. What do you think is kind of the steps going forward? How is this going to proceed when they say, we're going to begin looking into this?
Alex, you want to start?
Sure.
Or I can.
I'm more than happy to start, or Keith.
Alex is a little more free to speak. By the way, real disclaimer for Keith. He does
I was going to give the disclaimer, but yes, I have a disclaimer I have to give.
Okay, good.
All right, so first of all, is this on? Everyone can hear me? Good. So I think that, in terms of the announcements, the recent announcement this week, and then a few months ago, the announcement by the FTC of the formation of a tech task force, what that's done, at least from my perspective, is announced to the market, to market participants, to stakeholders generally, that both agencies are serious about these issues, want to do something to investigate whether there are legitimate complaints in the marketplace, legitimate harms to competition in the marketplace. And so I think what you'll see evolve over the next several months, maybe longer, is a number of people coming into the agencies to offer complaints or perspectives on what's going on in the market. You'll see people come in to just educate the enforcers about the market dynamics in the various impacted markets, and talk to them about whether or not the agency should consider moving forward with some type of a formal investigation and potentially thereafter some type of an action. So I think these things tend to take time, at least in my experience. The agencies ultimately have to gather facts and develop theories that are grounded in those facts, right, to build a case. And so I think that's what you're going to see over the next several months.
Yeah, I would add to that. First, I'll give the disclaimer, though, which is, as you heard Commissioner Wilson say before, I speak only for myself, not for the Federal Trade Commission, not for any commissioner. I would add to what Alex said, I think the announcements have been a little bit unusual. That is not typical for the way that we conduct business. I think Chairman Simon said a couple months ago, if you read about it in the news, some sort of complaint, some sort of problem, you can be assured that we are looking into it, that someone is investigating. And I think that has typically been the approach before. We are constantly opening and closing investigations. Sometimes you hear about it. Often you do not. That doesn't mean that nothing is happening.
Yeah, I think that's an important point. If you can go to the ftc.gov, for example, and you can see all of the merger considerations where you choose, say, maybe there's not an issue here and you choose not to take an action, or you do take an action. And I think a lot of those do go under the radar and people don't end up talking about it. But you commented that, this is a little unusual, that we're hearing a lot of discussion about that. And I started with statements from the campaign trail, Senator Warren, Senator Hawley, stuff like that. Is there a concern of kind of politicization of the FTC DOJ merger antitrust reviews, and how do you combat that?
I guess I would start by saying ultimately both FTC and DOJ are law enforcement agencies, and so we have to satisfy the legal standard. Neither agency can take action by themselves. We cannot decide to block a merger, by fiat. We cannot decide to impose some sort of sanction or breakup of a company by fiat. We need to go to court, and in order to do that, we have to file a complaint, and the standard we have for filing a complaint is a reason to believe that the statute has been violated. So we have an initial bar when we file a case that would have to be satisfied. And that would require an investigation, find, both the law and the facts to say we really think we have a case here. Even after that, we still have to convince an Article III judge at some point along the way that there has been a legal violation. So I would push back against the idea that somehow the FTC or DOJ by themselves can do anything, let alone, because it's been directed.
And Jeff, you're at the National Venture Capital Association, so clearly you've got members who are looking to do investments in startups with the hope for acquisition by some of these larger companies that are under consideration. But by the same token, you have members who may be concerned, and they're smaller ones. So where does NVCA land on this dichotomy? How do you address the concerns about big tech?
Sure. Thank you very much for the invite. It's nice to be among so many friends today. I think what I would start by saying is that the venture capital industry, by its nature, is very diverse. At NVCA, we represent around 350 venture capital firms across the country, and they range from a lot of the very large ones that you might have heard of, like NEA and Sequoia and Kleiner Perkins, and on down to very small regional funds that you probably have not heard of. And so you tend to have a real diversity of opinion that is largely based upon people's experiences. And so the one thing you should probably know is, as we kind of think about this, is that over the last 10 to 15 years or so, the venture capital industry has become a lot more of an M&A-based business where you have less and less IPOs, and that's something that is very unfortunate from where we sit. 20 years ago, you had twice the number of public companies, and that impacts everybody in this audience and every policymaker, because whether you're saving for retirement or trying to make earnings in the public markets, you now have less companies to be able to choose from. And if you look at a company like Microsoft, they went public at something like $100 million valuation, and people have been able to kind of ride that wave in the public markets. And today, a lot of the venture-backed companies that we deal with aren't looking to go into the public markets until they're in the high single billions, if not $10 billion market valuation. And certainly you've got recent cases of companies like Uber that were, I think, at a $60 billion valuation or something like that. And so because you have a lot more M&A activity, especially among some of the big tech companies, you do have varying perspectives in terms of how people are treated in the marketplace. I certainly have many, many anecdotes to draw upon of members of ours who have dealt with, by virtue of being investors in these companies, with large technology companies that have felt very abused. They felt like the intellectual property laws have been inappropriately used against them, as if they're perhaps at times there are competition concerns and whatnot. On the other hand, you have a lot of people who look at some of the big tech scrutiny that's gone on in the larger techlash movement, and they are really concerned about what the consequences might be of this. Because if you do have breaking apart of a lot of these companies, it's kind of like a butterfly effect where you don't really know what the outcome might be. And so since a lot of these smaller venture-backed companies are not able to access the public markets, you do have them needing to rely upon M&A more so than in previous years. And then you have to ask yourself whether or not a lot of these companies would be able to really come in and fulfill that. And so there's a huge consequence for the country and for public policy, because it's a lot of these small, innovative companies that are putting dynamism in the economy. And we should not ever find ourselves in a situation where we're only relying upon really large companies to do all of the next generation technology that we all enjoy.
Yeah, and Chris, I saw you nodding your head a lot. You want to add a little to that?
So I agree with what Jeff was saying, and it's his business to actually follow these market dynamics, and so he explained it far better than I could. What I would add is that the picture that he described is why we've been advocating for going beyond the limits of just what antitrust can do to protect the marketplace. I mean, the DOJ and the FTC, as was said, are enforcement agencies. They can act when it comes to mergers. They can act, and we're welcoming the review that the DOJ has said they're going to do of the entire marketplace. We think that's a great thing, but we hope that it will point to some of the dynamics where there are concerns out there in the public about power that don't strictly come from prices being raised, that don't strictly come from, that really result from the unique nature of the digital marketplace, that the network effects of digital platforms are so much stronger than what we have traditionally seen in the tech space previously in, say, the cable marketplace or the broadcast marketplace. And that because of that, there are heightened competitive concerns that may require actual rules and regulation to actively ensure or promote competition beyond antitrust.
I'm just going to offer two observations on what Chris and Jeff said. So first of all, I think it's actually very difficult for an enforcement agency to distinguish between acquisitions that might actually be ultimately beneficial to competition and ultimately efficiency enhancing. So I'm talking about more vertical acquisitions of small companies that might offer a feature that's integrated then into a larger product set, and that becomes ultimately efficiency and consumer welfare enhancing for all of us, right? It's difficult to distinguish on a sort of rule basis, which I think is what you're suggesting, between those types of good acquisitions and what I think you all view as problematic acquisitions of small companies. And so I offer it more as an observation because other than the work that I've done at the agencies, which I think we did the right thing in looking at these cases, of course, I'm not sure what the answer is. I'm not sure how to exactly draw the line there. And so I'd be curious to hear, where, for example, you might draw the line between, an acquisition by a large incumbent of a small competitor or a small entity that offers what would ultimately be a feature, right, a complement in some type of an adjacent market. How do you distinguish between that and what you would consider to be a problematic acquisition? I think that is a difficult question that it was worth discussing.
So, and I don't know that I have a full answer for you right now, but I think this is why we welcome the review of the agencies. There are, in the digital platform world, there is a tremendous influence of data and its power. Data is the currency that a lot of platforms work in, and it allows them to offer wonderful, often free services or freemium services that are very popular. And those dynamics that come with an interactive nature for the user, that just compounds the power that they have that may not be seen in traditional antitrust analysis. So what we have been advocating for is to look at rules that may promote competition. So one that we've been advocating for is to come up with some sort of non-discrimination rule for platforms so that the values that have been consistent in the media marketplace around promoting small innovation, promoting small voices and independent voices in the marketplace, promoting localism, can continue to flourish. That those small voices that may need a larger platform to develop and to build a market can do so using a dominant platform, and there should be some sort of metric to determine when a platform is dominant that goes beyond the traditional antitrust analysis.
Sorry. So, I mean, to Keith, you and Alex, and Jeff, feel free to jump in on this. Do we see an inability of the current standard for antitrust analysis to address the concerns that Chris just raised of network effects, data? Is it possible to engage in robust antitrust merger analysis under the current consumer welfare standard that we have today?
There we go. I guess I'll go first. The way that I always think about an antitrust problem is we have the law and we have the facts. And the law does not vary. Carl gave you the Sherman Act that we had at the beginning of this discussion. We also have the Clayton Act for mergers. We have the FTC Act. We have a couple of laws. But those laws apply to everybody. And so they apply equally. And so I think we might say there are differences in the way that network effects apply in a particular market. There may be different facts on the ground in, for example, broadband or in cable or in television content, but we don't apply a different law to them just because they happen to be a TV network instead of an internet provider. And so I think it's important to make that distinction up front, that every market and every investigation is going to have its own facts, and those facts may lead us in one direction or another when we're assessing, does this harm consumers, and therefore, does this violate the antitrust laws? But ultimately, it's always going to be a fact-dependent exercise, and it's going to depend on how competition in that market actually works.
So let me offer a bit of a defense of the existing antitrust standards, and then Chris, I'm sure you'll want to respond. But and there's going to be a bit of a nuance in how I respond. So first of all, I do think that the antitrust laws are currently, very capable of addressing a lot of the issues that Chris identified. So for example, if there was a platform operator that was dominant, we can discuss how that should be defined, but if there was a platform operator that's dominant and is using its position as a dominant operator to discriminate against companies that operate on that platform, that in a business where it competes, that's something that could be addressed under the current antitrust laws. It's a type of exclusionary conduct that could be gotten to. In addition, on sort of the merger side, I think that you discussed or you'd asked about data. And so the DOJ, the FTC have looked at data aggregations and agglomerations through mergers for decades and have been very capable of dealing with those issues, particularly in, I think it's come up most frequently, at least that I've seen, in the financial exchange space. So there was Thomson Reuters merger, I guess 10 or so years ago, where the agencies took a look at how unique the data set was that these two market data providers created, and how difficult it would be for entry into this space because of the fact that the data was extraordinarily difficult to put together and to maintain on a real-time basis in a way that was relevant for the financial analysts that tended to use it and to purchase it. And they were able to enter into an appropriate consent that was their structural divestiture in that case. So, and there's plenty of other examples at the FTC as well. So I think that the laws are currently capable of dealing with most of these situations. Now, the nuance that I was going to get to is that I do also believe that the law has to, over time, evolve to capture new competitive dynamics and new markets, new business issues. And so to the extent that you can sort of slowly evolve the antitrust laws to reflect what's going on in markets, I think that's actually advisable, and it's been done for years, and it's typically done through the common law, which I think is the best way to get at those issues, to litigate them out. But as a matter of sort of looking at standards, I think that the standards under the current antitrust laws are sound, and I think that the consumer welfare standard in particular, while I would be the first person to advocate for a better definition, right, a more precise definition of what consumer welfare means. I think it's served us pretty well over the last 30, 40 years. Thanks.
On this issue, what is the appropriate standard? I know you have to be careful in what you say, but what were some of the takeaways on that?
Yeah, I don't think I can go into takeaways yet, but you're right that it was a pretty large effort, and so I've got some statistics here. So this is kind of the second large hearing that we've had like this. This hearing has been called the Hearings on Competition and Consumer Protection in the 21st Century. And this was one of the chairman's signature initiatives when he took office, was to say, the markets are evolving, the way that folks do business is evolving. Does that have implications in terms of the facts for the way that we apply the antitrust laws and the consumer protection laws? And so this is really, in some sense, part two. There was an earlier set of hearings in 1995 under Chairman Potofsky, and this is kind of a second effort at considering updates to that framework. So in that vein, we invited hundreds of speakers. We had folks from the academy, we had consultants, we had public interest groups, advocacy groups, and representatives of business and industry. The hearings started in September of 2018. They just ended in June of 2019, so it was actually more than 6 months, yeah, Carl. 14 sessions over 23 different days. We had an online audience of more than 21,000. We received close to 950 unique written comments from individuals, from companies, from public interest groups. It received a couple from public knowledge. We also received, I think, one or two from you, Carl, and from other folks across the spectrum as well. I think just to whet your appetite, so everything is available on the FTC website, but there are some topics of particular interest, I think, to the folks in this room. We had a day or a unit on digital markets. We had a unit on the acquisition of nascent competitors, innovation and intellectual property, vertical mergers, privacy, big data and competition, algorithms, artificial intelligence and predictive analytics, data security, consumer privacy, and broadband internet markets. You're right, we are still digesting. It's a voluminous record. It's thousands of pages of testimony if you look at the transcripts that are posted, and many thousands of pages more when you look at the comments. But I do expect that there will be output from the commission. I think it's going to take several more months at the least, and I couldn't tell you more than that, but expect to hear more from us.
Jeff, one of the things that we've heard are concerns about the loss of small businesses, and you mentioned earlier that having these large players in the space can threaten investment, but we've seen breakouts that you wouldn't otherwise expect. I mean, we talked about Zoom as an example, and can you just talk about some of your members who seem like they're entering into an area where a large incumbent could just squash them, but have been able to break through, and why do you think that's happening?
Yeah, so I think that the thing to kind of consider in this whole thing is when a venture capital investor is looking at an investment, they're trying to figure out where this company fits into the broader landscape. These range from issues thinking about, is this the right time? Is this company, can it thrive today? Or would it be better to thrive in 5 years and where the marketplace might go then? Also thinking about where they fit vis-a-vis a lot of other competitors. And so you do get into a lot of these considerations, and there's been a lot of ink spilled on the issue of the so-called kill zone. And is there a spot here where the startup is going to enter the marketplace where a large incumbent could squash them quite easily? And that might range from doing things that are a little bit easier, like hiring all the world's most valuable engineers in that space, or paying everybody at the incumbent company a lot more money to do whatever it is, to things that are probably a lot more offensive, like daring the smaller company to litigate against the larger company and then trying to effectively kill it through litigation and things like that. And so venture capitalists are very skilled at considering the entire range of these things, and oftentimes they're trying to find that special company in a spot that's going to be able to withstand tremendous odds against it, because it's really daunting when you think about what a young company is up against, because you've got both a huge amount of regulation and whatnot that seems to be new every day. You've got all these large players that you're competing against, and then you have all just the really tough things about running a company. And so this is something that VCs spend a lot of time trying to consider, whether or not they've got something special that can fit into the marketplace. And so I think that from my perspective, I know that the gentlemen up here are all very knowledgeable about antitrust laws and whatnot. I don't have any prescriptions in terms of what types of M&A activity should be permissible or not, but I do think that what would be helpful is some type of rules for the road that enable a small company to think they have at least a shot at being able to take on a lot of larger incumbents. And you do see a lot of the large technology players where you just don't see a lot of challenges to them, and say the social media aspect or something like that. You did cite the example of Zoom, and for those of you that are not familiar, this is a new teleconferencing platform, and NVCA uses it, and I'm sure a lot of your companies use it as well. And it's kind of an outlier in some ways, where you have this space that is fairly commoditized, where there are lots and lots of free conferencing services that are out there, and they seem to have kind of shot ahead. They had a very successful IPO, notwithstanding the fact that there were lots of competitors out there that, an entity like Google could have probably quite easily created, something to compete against them. But I think the example of Zoom is it's probably more useful in terms of it's a bit of an outlier that now you have this standalone company that was able to successfully go onto the public markets, and it has an employee base which is beneficial to all of us, and it didn't have to look at being acquired by a larger player. And so I think this gets back to my original point, which is that we do have a lot less public companies than we used to have, and we have a lot more feeding into the larger players. And while some of that is healthy and necessary, it's probably gone too far, and we probably need to have an environment where we have a little bit more spreading out and having some of these smaller cap companies being viable standalone businesses.
Excellent. So looking at, we talked about breaking apart, and butterfly effects were some of the words that were used. One of the things we wanted to do on this panel is to look to some historical examples. So oftentimes we get stuck in the immediate image picture of what's going on today, and we sometimes forget what happened in the past. I will start with a rewind of 100 years, and Keith, if you can kind of tell me about Standard Oil, because Standard Oil gets cited a lot as the preeminent original antitrust basis, but I suspect none of us were alive when that happened. So can you give us some context on what actually happened there?
Sure, and thank you, by the way, Carl, for picking something that is such ancient history that I'm pretty safe regardless of what I say. So on that, yeah, Standard Oil was a case decided in 1911, so it's more than 100 years old. It actually started, I think it was 1902 is when the case started. Trial alone took more than 2 years because they had 444 different witnesses that were called in the course of that trial. It was an enormous undertaking, and it was especially enormous at a time when the antitrust laws simply weren't enforced very much because they were fairly new, and people didn't really know what they meant. And so that is one of the important takeaways from that case. That was one of the first opportunities for the Supreme Court to look at the statute that Carl put up earlier and say, what does it mean to monopolize a market? We don't really have that word in the dictionary, so let's try to put some meat around what monopolize means. And let's put some meat around what it means to have a restraint of trade. And ultimately, that started down the path that we have today. I think Alex talked a minute ago about the common law and about how the law evolves slowly, case by case. And this was really the beginning of that journey that we're still going through today. In terms of kind of its significance and why people remember it that aren't nerdy lawyers like me, I think folks remember hearing that Standard Oil was broken up and that Standard Oil used to be a trust. And I think those facts are actually intertwined. Standard Oil was a trust in the sense that it was a combination of many different businesses. And each of those businesses had a separate corporate structure and separate shareholders. And they contributed their shares to a holding company, essentially, that would hold those shares in trust and operate their business in trust. And so it made it easier then to break up the company when it was determined that they had monopolized the market, because there were 30 or 40 odd different companies that each had their own shareholders. And so the order from the district court and eventually the Supreme Court was simply return the shares that you're holding in trust and start competing with each other. And from that, we had Amoco, we had Exxon, we had Mobil, we had several other, sometimes called baby standards, kind of less of a catchy term than baby bells, but it's the same concept.
Well, speaking of baby bells, Alex, the other big breakup that often gets cited in the discussion of tech is AT&T, and can you talk about the breakup there?
Sure, I'm happy to chat about that in a sec. I wanted to just address one point that was made earlier about sort of establishing, I think Jeff, you had mentioned establishing rules of the road for relatively small companies with respect to how to deal with larger incumbents, and something that would be beneficial for competition. And one of the things that I wanted to make a point about is that, at least from my perspective, before we begin to create prescriptive regulations for competition or before we begin to set up overly burdensome rules of the road, so to speak, I'd want to see some kind of real evidence of market failure, right? Where we know that antitrust is not effective or has not been effective in policing a market. And I find it difficult to believe, given the robustness of innovation in the U.S. technology space in particular, that there is clear evidence of market failure in the U.S. And I would, a lot of the markets, particularly platform markets that we're talking about, are characterized by, sort of winner takes all dynamics or winner takes most dynamics. And to the extent that new players come in, it's typically by virtue of disruptive innovation. They find out a new way to market a product or service or package a product or service for consumers, and ultimately they're able to get out from under whatever the primary or dominant platform is or was. We see examples like with, I remember AOL, 20 years ago was viewed as this, incredibly dominant platform. No one was ever going to get around AOL. 5 years later, they were pretty, they had been surpassed by a lot of other players in the same space who basically created a new and better mousetrap and got around them. And so I just want to offer sort of words of caution that before we kind of go forward with rules of the road, and I know, Jeff, that was just sort of an observation of yours, but, but a lot of people are talking about that. They're talking about sort of replacing antitrust standards with prescriptive regulations, and I just want to caution that you can end up effectively calcifying the existing market dynamics for a longer period of time than they probably should be, right? You're basically entrenching potentially an incumbent by virtue of those regulations. So I want to just offer that as a bit of caution. Chris, you had, looks like please go ahead.
I'd love to jump in because I really appreciate Alex's caution. And I would actually agree with it. This is why I think, we and others reacted strongly to the DOJ taking a review of the full marketplace, because analysis is required to really determine the state of the marketplace, where there are harms, and the power that antitrust can have in solving some of those harms. What I would just offer is that things have changed since we moved from Standard Oil to AT&T to, let's say, a Facebook and a WhatsApp merger, or any number of mergers that might be happening with Google. When it comes to these new mergers, yes, AOL came up in a time where there was not the same level of data collection and using data as a cost to pull consumers in, and the power of data and the opportunity to use algorithms was not as developed. But technology has changed so rapidly that we've now seen a marketplace where we're not seeing the same sort of disruption that we saw, a decade and a half ago. And that's worthy of review. That's worthy of analysis. And then we should take that analysis and come up with decisions. So, I know we're not actually asking for any sort of replacement of antitrust by rules. We're actually asking for an appropriate complement based on analysis. And based on that analysis, we hope that folks will factor in the changes that have happened since the time of AOL, since the birth of the internet, and now this move into Internet of Things, big data, and vast mobile networks. It is a different type of internet than we saw in the late 90s when I was coming out of high school. And so that's why we've entered some concepts that may not be the right metric, but should be considered and discussed among policymakers as they look at these sorts of reviews. One that my colleague put out there is the idea of a cost of exclusion metric that could be formed to to measure the impact of network effects in digital platforms. That when you reach a certain tipping point with a social network or a digital platform, that there is a certain cost to not be on the network to the consumer, or even to a small entrepreneur who may find that service valuable. And does that have a prohibitive effect on competition rising up and being disruptive, or just being a competitor? We're concerned that it may, and that's worthy of analysis and review.
So just very quickly, so I disagree with a lot of what you said, but I also agree with the notion of an evidence-based approach to antitrust, an evidence-based approach to any kind of regulation where we might have very strong proof of a market failure or a market inefficiency that needs to be resolved, sort of by consensus, resolved by regulation. So I think with that, very quickly, Carl, do you still want me to talk about AT&T? I can just give a...
Jeff's going to jump in,
All right, Jeff, go ahead.
then we'll
Yeah.
go back to AT&T.
All right.
Go ahead, Jeff.
I'll just briefly say, I don't think this was what Alex was trying to say, but just for clarification purposes, I mean, I think I'm certainly not standing up here arguing that there needs to be some type of, new antitrust prescriptions that need to take place. In fact, I think, some of the examples I cited is some of the competitive harms that exist for young companies are kind of outside of that space, and they might be in, sort of just more kind of business concerns and whatnot. So, if anything, I'm more fearful of situations, if you look at something like the privacy context, where if you start to have very prescriptive rules that are put in place, that actually is incredibly harmful to young companies and perhaps would not help them compete against a lot of larger players that I think that a lot of us like to see them ultimately do. And the reason for that is that when you live with some of these young startups, they are not hiring general counsel's offices and chief compliance officers and so on and so forth as their first, however many hires. And oftentimes when they're raising money, it's to hire things like engineers and scientists and so on and so forth. So there is a lot of good news out there in terms of innovation that's going on. So certainly don't count me as somebody who's trying to make this into something that it shouldn't be.
Briefly on AT&T, and then go ahead.
Okay, sure. So I'll give my own kind of
And you can talk about Microsoft too.
Yeah, I'll talk about Microsoft too. So, well, with respect to AT&T, I mean, it's a very long, drawn-out history. The government and AT&T litigated for, I guess, 40 years, really starting in the 1940s, back and forth. But ultimately, at least from my perspective, AT&T was treated as a heavily regulated monopoly for decades, and the FCC placed a mandate on AT&T to provide universal service. As a consequence, one of the consequences was that AT&T was alleged to have, you were required to rent equipment from Western Electric, which was affiliated with AT&T. They would allegedly overcharge on long distance to subsidize local or to subsidize rural service to sort of fulfill these FCC common carrier mandates. And so ultimately, the DOJ took issue with some of that conduct. They, again, were involved in litigation for decades and resolved that through a consent in the early 80s, which is quite famous, and ended up with breaking up the long-distance service from the local service and also placing other restrictions and qualifications on the entities. And then turning to US v. Microsoft, again, that was long-running in the 90s into the early 2000s. There, Microsoft was alleged to have a monopoly in Intel-compatible PC operating systems. Microsoft disputed that relevant market very vigorously. They thought it was too narrow, and perhaps it was. But ultimately, there were allegations of conduct that Microsoft was engaged in at the time to restrict the ability of what was viewed at the time as rising middleware and internet access browsers from gaining any traction with the marketplace. So Microsoft was alleged to have placed licensing restrictions on OEMs where they would have to feature Internet Explorer and not remove Internet Explorer as the default, for example. Those types of activities. They integrated the code for Internet Explorer into Windows, and when taken to court, were unable to at least persuade the court that they'd done that for pro-competitive reasons. So it was a very, very actually complex set of facts, but ultimately that was resolved through a consent. There was talk of a breakup at one point between the operating system and the rest of the company, the sort of software application piece of the company, that did not come to fruition. It was resolved by consent in the early 2000s, and I think that the consent decree expired in 2011. It was a 10-year decree.
Yeah, so Those are two examples where defining the market's important. We saw with XM Sirius once upon a time, they proposed a merger, and everyone was trying to figure out what is the market. Should the market be 2 satellite broadcasters only, in which case you are creating a monopoly, or should it be a broader monopoly, or sorry, broader market with terrestrial radio included, the iPod, because the iPhone didn't yet exist, and other features. Eventually, the Department of Justice went with kind of the broader approach and allowed the merger to go forward. But what do you do when the market is something like Taylor Swift? So, and hear me out on this. So, about a decade ago, we had Ticketmaster merge with Live Nation, and they are heavily engaged in online ticketing. And they're now engaged in kind of restricting resale on the secondary market. Now that consent order is expiring next summer. And let's take a look at that merger and if we think that one should have been allowed to go forward, because that is tech related. It's online ticketing, it's the evolution, and it's something that's not as easily penetratable as a market, because at the end of the day, if I want to go see Taylor Swift, there's only one place to see Taylor Swift. Yeah, go, please.
I mean, I'm happy to jump in. I'm not sure
panel.
that I agree with the relevant market being Taylor Swift, but let's go with that for now. Look, I don't know if I can sort of second guess the Ticketmaster consent decree. I think if I recall it correctly, and that may have been when I was at the agency, but they forced a divestiture of a competing ticketing service. They said that I think Live Nation had been a secondary ticketing service. Live Nation had been moving into direct ticketing as well, and Ticketmaster may have been moving into concert promotion as well, and so they prevented all of that from occurring per the consent decree, if I'm remembering it correctly. It's been a while. But you know, so ultimately what I think they tried to fashion there was to make sure that there was going to be an alternate provider, an alternate competitor in the space. It's, to my mind, very much a vertical deal, right? In that what was allowed to go through was very much a vertical deal. And those can be very difficult, particularly in a circumstance where, if I recall correctly, Live Nation had, 80 or, control of 80 of the most prominent venues in the U.S., as well as all of these, the promotional rights for a number of artists. And so, that's a case where you have Ticketmaster sort of sitting. It's a classic vertical case that could create problems, where you have Ticketmaster sitting in 2 markets that are vertically related, and anyone that wants to come into those markets to challenge Ticketmaster presumably now has to enter in both those markets. I think that given the prolonged dominance of the 2 of those entities, at least based on anecdotal knowledge, I don't know what their market shares are today, but it seems like they're still, particularly in the market for Taylor Swift, they're dominant. And it's 10 years hence, and no one has been able to kind of successfully, to my knowledge, enter and challenge them in those 2 vertically related markets. So as a consequence, the result would be, or the conclusion would be, that the consent decree was not successful in spurring additional competition. But again, I'm basing that sort of on anecdotal evidence and a Taylor Swift market.
Chris, I saw you nodding.
Just an
Also a Taylor Swift fan, I understand. So
you've been listening to my Spotify playlist. I would just add that I think the benefit of reviewing some of these consent decrees as they come back is a chance to evaluate them given the shift in the marketplace. I think similar to what you're saying, that some of the changes that we've seen in the marketplace is the explosion of big data, the movement to online sales, and we've also seen a challenge to the concept of the ability for those sales to be transferred to the secondary marketplace. And so, Ticketmaster, having a dominance in this first sale of tickets, and how do we ensure that when folks buy tickets, they're able to actually move them as their own property, as something that they bought and they spent their hard-earned money for, is important and needs to be analyzed in the marketplace. And so those dynamics of online sales, data collection, and down-market sales, I think should be factored in.
Can I make a very important, Chris, I think, clarification or response to something you said there. I think that one of the big differences between this hypo where we're talking about a Taylor Swift market is that, at least from my perspective, going to a Taylor Swift concert, that's perishable. It's sort of a one-time thing, or however many shows she has, you have a limited number. Whereas I think in most circumstances, when you talk about online competition or tech platform competition, a lot, I don't know if all, but much data is ultimately, replenishable. It's non-rivalrous, and so there are distinctions there that you have to take into account between, sort of this hypo that we're talking about in online competition.
That's a great point, and I agree. And I think the technology is there that we should be investigating opportunities for digital ownership to be transferable and protected at the same time. And that's probably a different panel, but it's a factor that I think is very important to us.
And we have another consent decree that's coming up for review. That's Google ITA. That gets into the data component. Back in 2011, Google had a merger with ITA, which is a travel agency, and that's up for review now. Keith, were you at the FTC at the time, or?
I was not, and I'm on record on this case, though, so I'm glad to talk
Excellent,
to it.
please.
Actually, Commissioner Wilson and I wrote an article when we were in private practice criticizing Google ITA, among other cases. Not so much in the thought that, the DOJ saw a problem and decided to take a remedy, and I don't think we disagree necessarily with the idea that there was a problem. What we're really focused on, okay, so there's a problem. What do we do about it? What is the remedy in this case that will fix the competitive problem? And I think there's kind of a range of opinions within the antitrust bar about what kinds of remedies are effective and what kind of remedies really work. And so I mentioned, we talked before about Standard Oil or AT&T. Sometimes people go straight to a breakup, what we call a structural remedy. They say the only way to fix this is to have 2 or 3 or 5 separate companies. And then I think other times folks will say, we're more interested in altering their behavior without actually breaking them up, and we call that a behavioral remedy. I think what both Commissioner Wilson, not a commissioner at the time, and I found troubling about Google ITA is that in that case, some of the remedies the DOJ imposed were really pretty unusual. So one of the things they required Google to do after acquiring ITA is to continue developing a product that did not yet exist. They said, you're working on a product, we hear that ITA will have this product in 2 years' time, so you are required to complete the product, whether or not you run into any developmental difficulties, whether or not anyone ends up wanting the product in 2 years, you are required to create it. And they set milestones for how much money Google had to spend creating this product over the next 2 years. And they said once you finish creating this product, you then have to license it to any competitor on fair terms. And, query what that means. And so, there's always this tension, right? I mentioned a minute ago that the facts always matter, and we're always trying to think about what is the correct remedy for this case, for this problem. But I think there are some types of remedies that categorically make people very uncomfortable, such as requiring companies to create things that don't exist in the future.
And we've spent a lot of time talking about vertical mergers. So that's basically, where you're non-rival, you're not a competitor and I'm going to buy them. But we did have a recent acquisition, very big one, that was a horizontal acquisition. That was Disney Fox. As somebody who is likely to be paying a lot of money to Disney for their new streaming service in the fall, this one is a concern to me. So how should we treat horizontal mergers differently from vertical mergers when we're looking at allowing these mergers to occur? And you can talk about Disney Fox if you want as well.
I'll take a first crack at that, and I think that, so first I want to respond on Google ITA, just because I was at DOJ and I worked on that matter, and I know Keith doesn't like it, but look, there I think that the record shows that what the DOJ asked for in the consent reflected the business plans of the company that was being acquired at the time. And so it was a continuation of those plans to allow the market to retain access to data and sort of a back engine. So what ITA did, and still does, is provide a back engine for online travel agencies like Orbitz, for example. And what the DOJ decree attempted to do was to make sure, because Google was going to be entering into that online travel agency space, the consent decree sought to continue to allow Google or force Google to provide data for the back engine for those competitors who were reliant on it, because there were no reasonable substitutes out there in the market for that. It was a pretty unique set of facts, I think, that in that circumstances warranted a vertical decree or vertical resolution. And I'll use that to segue into sort of a broader discussion about vertical versus horizontal. Historically, the agencies have looked at vertical cases and hewed to and tried to develop a consent decree with the parties that allowed for a conduct remedy, right? Because otherwise you would be blocking deals that ultimately, in most circumstances, vertical deals, I think is documented, are ultimately pro-competitive. So you don't want to over-enforce in that space and chill innovation through acquisitions of vertically related products and services. On the horizontal side, historically there tends to be more structural remedies, right? A divestiture of some kind to eliminate an overlap, direct competition between two head-to-head competitors.
So,
Yeah, go ahead.
and I should add, Alex, it was in the article, but I'll say it again. We didn't have access to your case file or your evidence. And so, like in any case, at that point, we were looking on from the outside and we were saying, based on what we know, how do we feel about this? But we recognize that the facts are a little bit different when you got more.
Absolutely, and look, and I will say I can only talk about what's public anyway. But I thought that was it was a unique circumstance that warranted that kind of a consent.
So we're going to open up to questions in a minute, but before we jump there, Jeff, one of the things that I think would be interesting is if we discourage the ability of large firms to make acquisitions, does that encourage the large firms to just try to create their own copy of what somebody else is developing rather than just doing an acquisition?
I think it's a hard outcome to predict. I mean, if there's one thing we've seen is that a lot of large companies have had a difficult time doing a lot of innovation that's really been game-changing. It's one reason that you've seen a big trend in the venture capital industry has been the establishment of corporate venture capital groups. It's why you have things like Qualcomm Ventures and JetBlue Ventures and Lockheed Martin Ventures and so on and so forth. And so I'm not quite certain what the outcome might be, but I think what I was saying before is that I think the policy preference is to have an appropriate blend where you have small companies that are able to thrive and ultimately become standalone competitors, but also be able to have the option for the company to be able to sell itself if it makes sense for that company, it makes sense for the investors, and it makes sense for the larger company. And then, of course, that's where the experts on things like antitrust need to come in and figure out if there's any sorts of unrelated problems that I'm not considering.
Okay, so any questions from the audience? Yes, sir. Oh, sorry, there's a mic coming that we are required to wait for, so.
Aram Sinreich, American University. So I'm glad you brought up the issue of vertical versus horizontal integration. I want to pose so in the academy, we've spent a lot of time trying to figure out what these things called platforms actually are. Is it possible to think of data, which is the kind of central commodity on these platforms, as a kind of third direction, right? A third axis. You have the vertical axis where you're thinking about a traditional supply chain. You're thinking of the horizontal axis in terms of the key players in the space. But given that data flows up rather than down, and given that there are network effects that make traditional analyses of market concentration irrelevant, and given that data is something that compounds when you combine traditional infrastructure with traditional content and services, could we think of the concentration of ownership over data as something that's neither vertical nor horizontal, but an added axis of analysis? Sorry, I'm an academic, so I tend to ask these big thing kind of questions.
So we're going into the third dimension of
Well,
antitrust.
how would that affect an antitrust analysis, right? How do you think about concentration of data when it's not really something that behaves like vertical integration or horizontal integration.
Alex, why don't I start, but I'll...
No, please, go ahead.
Yeah. So what I would say is we typically in the antitrust agencies think that data is either a product or it's an input. So, and my boss gave a speech about this a couple months ago at CCIA that you can find on the website where she goes through it. And Alex, I think, is actually published on the topic as well. But there are times and there are cases that the FTC brings where the product really is the data. And we did a case a couple years ago called CCC Mitchell, which was called Estimatics, but it was basically a database that was compiled on how you would fix a car and what the price of a bumper is and what the price of a steering wheel is. And they would sell that data set to repair shops. And so there we were analyzing data as the product itself. And the relevant market was who else offers this data set to these customers. I think other times data is the input. I think that's probably more what you're thinking about, kind of the new economy. We've got social media where we're using data, but we're really using it to sell to advertisers, and so it's an advertiser market. But I think, it is different, but I don't know that it is that different from any other input. It just happens to be non-rivalrous, whereas, a lump of coal or a lump of iron is rivalrous.
Well, so I love that breakdown of product versus input because it really, your position on that oftentimes can depend on where you sit, right? And so for a consumer, a big chunk of the debate right now around consumer data privacy and collection is about data as an input where it's treated as a product by some of the companies. But then when you think of it as an input on the consumer side, what control should you have over that? It's not a lump of coal, but it's certainly highly important to the daily lives of average consumers that it's being collected from. What is that worth? Can you put a value on it? When people start talking about putting a value on it, then you get into questions of can or should it be given away? So there's a lot of concerns around data that I love your question. I don't know that I have a full answer on it, but well, so yeah, with the cost of exclusion analysis, we start to touch on it. I think some of the thoughts that we've been putting out around the idea of pooling and sharing data that once it's collected and it's providing this resource. Vertically and horizontally, in a third dimension, as you said, that it's something that in a competitive space, everyone should be able to benefit from. And so we're strong advocates for data portability, and we're even stronger advocates for the idea of interoperability so that that data can move from competitive service to competitive service or move from competitive service to dominant service and back as directed by the consumer. How to achieve that, I don't think we have the details on that, which is why I said I don't have a full answer on it. But that would be an interesting policy goal that, again, goes beyond antitrust analysis, but represents the values that I think consumers and the general public have about getting control over the dominance that comes from data collection.
So I'll just add a couple of small points. So I generally view things the way that Keith mentioned. I think that data is generally either an input or a product. But I think your question really begs a couple of other questions. So first, and people are working on these issues, like you need a sort of a better taxonomy of what platforms are online, right? There are all kinds of different platforms that use data in all kinds of different ways that have very different levels of cross-platform network effects. And as a consequence, the answer to your question, I think, might be different depending upon the platform that you're talking about. Whether it's sort of an attention platform, sort of social media, something along those lines. A transactional platform is very different, right? Like financial exchange or, payment network. And then you have, we talked earlier about some of the cases in with software platforms, right? And it's also different, and the network effects are very different there. And the relevance and portability of data might not be as relevant for a software platform. Anyway, so that's one issue. And then the other issue that I think bears a lot of thought here is sort of what data are you discussing, right? There's also a very large body of literature on the taxonomy of data, whether it's volunteered or inferred or other types of observed proprietary data, things like that. And so I think you need to, you'll have to sort of peel away all those different layers, because I think the answers to your questions will differ depending upon both those two dimensions, the platform that you're talking about and the type of data you're discussing.
Can I just add in, because I forgot to mention, to your question about the definition of a platform, and since you brought up my colleague Harold, who wrote a book that posits a definition, I'll just reiterate his definition, because I think it's interesting based on what you were describing. The idea that a platform that that does not have an interactive service is less of a competitive threat. Is basically a major part of Harold's definition, that a regulated, dominant digital platform needs to cross the hurdle of actually having interaction where the user can have multiple roles. And that when you have a digital network that allows the user to have multiple roles, so whether it's social media, where you're a consumer but you're also a producer of content, or if you're talking about a digital marketplace where you can be a buyer or a seller, that the network effects then are so much stronger than when it's one-way communication, like say a platform like a Netflix, where you're by and large a consumer, and that's the only direction that the user can interact. That the network effects in those under that definition with multiple roles of the user creates that it's exponential rather than just singularly additive, and that by nature creates a greater competitive harm along with the data collection. So it's something that I think when we talk about a definition of a digital platform that actually needs rules is worth looking at in this sort of marketplace review and analysis.
I'll offer very quickly, if you're curious about sort of the taxonomy of platforms, that sounds like the Harold Fell book is a good one to think about, and you've already read that. But the OECD has put out some papers where they go through each of the different types of platforms and offer, from an economist perspective, views as to how to potentially treat those platforms.
Yeah, we've talked about data being a barrier to entry, network effects. But one of the things that I've heard discussed is diminishing returns to data, right? So the fact that Carl is a man, that's very valuable. But then you say Carl is, let's say, under 50. That's also valuable. But then the more data you get about me, you can begin to paint a picture to the point where you essentially approach an asymptote. It's an asymptotic curve, right? Have you heard arguments that even though you have a ton of data about individuals, it's becoming less valuable the more you get, the diminishing returns on investment. And at the same time, using monthly active users as a metric for size, because a lot of us have accounts on social media, and my wife, I can promise you, spends a lot more time on Pinterest than she does on Facebook, but she does check Facebook at least once a month. So how do we define network effects if we're defining them in monthly active users? And is data as big a barrier as we think it is?
So I guess I'll just start out real quick, and then Chris, you can.
Yeah.
Just a sort of lawyer's answer. It depends. Your lawyer's answer.
Thanks.
I mean, I think that it depends on the type of platform you're talking about. I certainly think that everyone in this room would agree that a lot of the value in, say, like a Google search engine, right, is its ability to give you long tail results for long tail queries, right? The very infrequent queries. And that's so there I would sort of challenge the notion, at least for that type of a platform, that there's the diminishing returns. Go ahead, Chris.
I was just going to say, I think we're still learning about the value of data, and we should, there's nothing wrong with continued study of its impact, because if you take, I'm trying to think of an example. Well, I think the best example is what we're seeing in artificial intelligence. Everyone who's working in AI and algorithmic decision making is concerned about having quality data. and that often means getting more data. And so there is a value to it. The more data they have, the better decisions they can make. Now, there's also studies that out there that show, and I'm not an expert in the advertising marketplace, but the idea that behavioral marketing compared to more contextual marketing, thank you, I was forgetting my terminology, that there's little increase in benefit, and yet big data is being used to run up the market in behavioral advertising. And so, there it may not have the same sort of power. I think we have to let this play out. I think we need to study it. I think as artificial intelligence becomes stronger and more refined, we'll have a better sense of the power of data, and then we'll know what value to place on and also what limits to place on data collection and data use.
Questions?
Thank you. Steve Del Bianco. The intervention and Chris seem to be focusing on this notion of a platform having network effects and data acquisition as creating unique and long-lasting powers that deserve a special level of scrutiny, perhaps even regulatory scrutiny, or perhaps you were only speaking with scrutiny if a merger were to be proposed. But I would ask, how do we reconcile that with so much of the factual record? A platform with the ultimate in network effects would be a social network, where the value of being there is a function of how many other of my friends are on the network. In other words, network effects in its purest form is something like, well, MySpace, which in 2006 was well past Google and the most visited site in the United States. 1 in 4 Americans were on MySpace in 2006. 3 years later, it was passed by Facebook, and 10 years after that, Facebook is completely flat in terms of the active monthly American users. So the dynamism of consumers that come and go, trends that fade, and competitors that blow past you would argue against some sort of special deference to this notion of network effects and data acquisition. We've already heard that our regulators do consider that as part of the analysis they do. But it seems to be, Chris, you're arguing for a brand new special category for platforms.
I am arguing for that, and I think, as a part of the analysis that we're calling for to test the categories that we're throwing out there, it's important to look at. I'm not an expert in the data collection practices of MySpace. I know generally about the time of the internet that it was dominant versus the time of the internet where Facebook is now dominant. I can read, but we need our experts to actually look at those sorts of practices, and because I would hypothesize that the marketplace has developed significantly, the technology has developed significantly, the ability to analyze data and to use big data has developed significantly since that time, and you can see it, or at least I hypothesize that based on the actions of a Facebook in this different era, where they take action to actually merge with and buy up potential competitors in order to collect more and more data. It's a rational business decision that we didn't see out of a MySpace. So I think there's more work to do to analyze it, but this is why we put out these ideas. We want there to be a discussion about this, and we think it should be taken seriously.
Also, just to set the record straight, in the case of MySpace, number one, as Chris pointed out, they not only didn't have a robust data infrastructure, they had zero platform for harvesting and deploying consumer data in a way that generated revenues. And number two, and this is more important to your point, there were network externalities that prevented MySpace from thriving after it had been acquired by Fox Interactive Media that had nothing to do with their competitive position in the marketplace and everything to do with the mismanagement of the property within the larger entity that has personal reasons attached to it rather than strategic ones.
So
mismanagement happens. Companies mismanage all the time. I don't know how you say they didn't monetize. They had $800 million in revenue in 2009. So MySpace was doing some monetization. I'm just suggesting to the panelists you have to look at the facts of network effects that were not a persuasive barrier to entry and competition.
Yeah, and I think that's where we would agree, and this is why I keep emphasizing the importance of analysis and why we welcome the review by the DOJ, because we need more light than heat in this discussion. We need the data out there, but at the same time, I think we can recognize some of the changes in the marketplace and the changes in the actions of certain companies as something worthy of being reviewed. And so, I think it's important that we step through this carefully.
So Chris, can I just ask a question? So your position isn't necessarily that these platforms require definitely some type of new regulation. You're saying we should study it? Is that the position that you all have taken?
Yeah, I think we've put out a concept based on observations in the marketplace that should be studied, a definition that should be tested, including our concept of cost of exclusion, because we feel that the antitrust analysis that has developed over time has been limiting and has largely been limited to fluctuations in costs as an impact on consumer, and the definition of a digital platform and its network effects have a stronger impact. It doesn't necessarily mean that when you conduct those sorts of analyses, would that lead to a breakup of a company? Not necessarily. You may not solve some of the harms that are being raised in public debate right now around companies by breaking them up. People have privacy. We heard yesterday about the settlement with Facebook. People have privacy complaints about social media and platforms like Facebook and others, and they're not the only one. But breaking up a company, I don't see as a solution to those privacy concerns. So let's be clear about what harms we're concerned about, whether it's competition or whether it's privacy or whether it's content moderation. Another one I don't think gets solved by antitrust. And let's figure out how we solve specific problems.
Well, two quick observations. One, it certainly seems from an anecdotal perspective that there's not that much durability, at least with respect to the platforms we've been discussing. As I've said before, it can vary depending upon the platform, the type of platform. But there's certainly a lot of, as the gentleman here mentioned, there are a lot of examples where we thought that there were dominant platforms that would never be surpassed or usurped, and they were toppled. You could maybe point to distinctions, and maybe that's what you're arguing for, is that we look at that more carefully. But I would also caution, I'll go back to one of the things I said initially at the beginning of the panel, that if you are talking about prescriptive regulations, if you're talking about regulating these platforms heavily, you could end up in a situation like the AT&T example we discussed, where you have a heavily regulated platform, you've essentially entrenched them as the dominant platform, and you've calcified the market and it potentially significantly eroded innovation in that space.
Melinda, I believe, has a question up here. Okay, yeah, yeah. If you can run, and while you do that, I will give a shameless plug. If you want to talk about content moderation, there's a panel on that this afternoon, as well as we had privacy. And if you want to jam them all together, there's one on Techlash at the end of the day. So go ahead, Melinda.
A lot of outlets to get a lot of frustration out today. Hi, Melinda Clem, I'm the co-chair of IGF USA, and I also work for Affiliates. So my question, I want to talk about data and size and how we start quantifying some of these things. There are plenty of things that are easily quantifiable, and then there are things that are also countable, but don't necessarily go into the definition of a size or market concentration and things of that nature. How do these things fit in today? I'll give you a couple examples, or how should they fit in. I'm thinking about minority investments, or strategic relationships, strategic partnerships that give large companies, maybe more benefits or more favorable pricing, some other sort of advantages. Are those factored in at all into an antitrust assessment? Or are we really just looking at the strict quantifiable things like revenue and customers, and dividing those things?
So Keith, what goes into your analysis?
Sure. So traditionally, and I think it's true today, an antitrust analysis always starts with a market. So, Carl was talking before about the market for Taylor Swift, or the market.
I'm glad that's going to be the takeaway.
That is. It's catchy. It's very catchy. And so I think sometimes there's been a trend over time in U.S. antitrust to define those markets more narrowly. And so the commissioner has spoken about this also recently, and it's something that we're thinking about, where before the market might have been the market for generating electricity by any means, whether it's uranium or coal or natural gas or whatever it is. And over time, those types of markets have narrowed. So then we had a case called Arch Coal in the 2000s where we said the market is actually for a specific type of coal that burns at a specific temperature in Wyoming. And I know we're not talking about the new economy, but I think the same idea sometimes holds, where we might not be talking about all consumers in all places, but we might be talking about targeted sets of consumers. Consumers that use this product in this way, or this particular community and how they use a product. And that's not always going to be appropriate because the facts matter, but there has been a general trend in antitrust to think in a more targeted fashion about a particular type of customer or community and what their competitive choices are.
Yeah, it's the super premium ice cream example, and if you want to learn more about that, you can do a internet search on it. So we had two questions in the back that I think we can hit, and then we're going to have to break for lunch. So go ahead.
Baron Soga, Tech Freedom. So, Keith, I'm not nearly as sanguine as you are that the FTC, doesn't really have that much power. It has to go to a court, and of course, in fact, merely bringing cases is enough to shut down mergers. The two agencies wield an enormous amount of power in the lawsuits they bring. The reason to believe standard, as you know, is that's not really much of a standard to me. The agency has to make some case, but they can make a case, and that has a big effect on the market. So when you combine that with the fact that this issue is being politicized, and I don't mean by your boss or your agency. I haven't seen the FTC doing that. But this president has politicized antitrust law more than any president in American history. He regularly rants and raves about specific media companies being biased against him. The Republican Party is now ranting and raving and frothing at the mouth about cosmopolitan elites censoring them. And it's very clear that they're trying to use antitrust law as a weapon, which puts your agency as a neutral, independent agency that's trying, as far as I can tell, to enforce the law in a very difficult position. You at least have the benefit of being independent from the administration. The DOJ doesn't have that. And we've already seen in several cases very serious questions raised about why they're doing what they're doing, why they brought the case against AT&T, why they essentially blocked Comcast from buying the assets of Fox, something that Rupert Murdoch desperately wanted, and then essentially handed those assets over to Disney. So the DOJ is rapidly losing the credibility that it's built up over many decades of being independent and applying the antitrust laws neutrally. So in this environment, again, this is not a critique of anything the FTC has done because I haven't seen them doing that yet, but I find it disturbing that people across the political spectrum are failing to learn these lessons. You have Democrats who are calling for things like Amy Klobuchar saying we should flip the presumption in mergers so that in large mergers, private parties should have to justify their deal. Well, it's very obvious what that does. That does what happens at the Federal Communications Commission, where the government then gets the power to dictate to private companies to extort from them conditions unrelated to the merger. So Democrats don't seem to have learned this lesson. Republicans, as far as I can tell, don't seem to care, at least outside of your agency. What do all the panelists think about how we can avoid further politicization of antitrust law and ensure that the law is really being targeted on consumer welfare instead of political agendas?
That is a big question. But I think it's a question that many people are asking, maybe not at that level, but people are saying, how do we keep antitrust focused on competition and consumers? And I think that's absolutely right. I think that's something that we think about at the agencies. I think it's something that we think about when we did the hearings. And I think my personal answer is that an adherence to the consumer welfare standard is the safest way to make sure that we are making objective, consistent decisions. I think you've heard other folks say we should abandon the consumer welfare standard. We should include all sorts of other considerations. In Germany, they had a recent decision that said privacy should be an aspect of competition now. And so I think at least I personally have taken the view that an adherence to what benefits consumers tends to be more objective than having 5 or 6 different goals that you can pick or choose from. Because if you have 3 goals that say yes and 3 goals that say no, then it becomes arbitrary. You can justify either decision. Whereas if you're focused on only one goal, you should at least have only one answer.
Okay, I guess that will end it since I want to make sure everybody gets to lunch. Please thank this wonderful panel. They'll be available for a little bit of time if you want to talk to them further.